Hello, my name is Peter Bricks. I'm a debtor bankruptcy attorney with offices in Atlanta, Jonesboro, and Cumming, Georgia. Today I'm going to talk to you about homeowners association dues in bankruptcy, but first I want to issue this disclaimer. We are a debt relief agency proudly assisting consumers in filing bankruptcy. There is no attorney-client relationship with the viewer of this message unless there is a fee agreement. We would have to meet with you individually to offer you applicable and accurate legal advice. This video is intended only for educational purposes. So today we're talking about HOA liens, homeowners association dues, and bankruptcy. So the first question is, which chapter are you in? Let's start it off with Chapter 7. If you're in Chapter 7 bankruptcy and you are current on your HOA dues, there's no debt to discharge. So the only real issue in that case is, are you still liable for dues after you file bankruptcy? Um, uh, and the answer to that is yes. That's true. I suppose it would be pretty unusual to be current on, or not typical for you to be current on your HOA dues and be filing bankruptcy with the intent of surrendering the home, but it could happen. So in that case, you file bankruptcy May 1st. Any dues May 1st, 2012. Any dues from May 1st, 2012 until the ultimate date of transfer of the property, be it a sale, a regular sale, a short sale, a foreclosure, a deed in lieu of foreclosure, what have you. The debtor is the one untitled. The debtor is the one responsible for the HOA dues. Now, I suppose if the debtor vacates the property, the homeowners association loses a lot of their powers, and that the lien they're putting on the house is really irrelevant to the debtor if they're, say, putting a statutory lien. However, if the dues are not paid, the debtor is personally liable and the homeowners association might come after them. So the other scenario was the Chapter 7 debtor who enters the bankruptcy case in arrears on their HOA dues. The arrears are discharged. The personal liability related to the arrears are discharged. Again, the debtor is liable from the filing date of the bankruptcy until the foreclosure. So you could have a scenario where the debtor vacated the property prior to filing bankruptcy, has continued to accrue homeowners association dues. The debtor might be $3,000 in arrears at the time of the bankruptcy filing. The $3,000 in arrears are included in the bankruptcy. They are discharged. And yet the debtor is no longer in the home. The bank might not, let's say it's even up for foreclosure. The filing of the case stops the foreclosure. So there might not ultimately be a foreclosure for, who knows, 3 months, 6 months, 12 months. The debtor, even if the debtor's not residing in the property, is liable for those HOA dues. Again, you have the scenario where the HOA might not try to collect. They might deem the debtor uncollectible, but technically speaking, the debtor's liable. The other scenario where the debtor enters in arrears is the debtor wants to stay in the home. Maybe the debtor's lost privileges and such. The debtor, actually the debt is forgiven, the debt is discharged going into the case. The debtor now kind of starts from scratch, with the one limited exception that if the HOA has got a statutory lien, this will, your state law will have rules on that. If the debtor does have the HOA does have a statutory lien that preceded the filing of the bankruptcy case, the debtor cannot wipe out that lien in bankruptcy. Therefore, you have the situation where the debt doesn't exist. So let's say, hypothetically, the debtor's being garnished. The garnishment would stop the debt. Not only the garnishment stop, of course, but the debt related to the garnishment is wiped out. However, the lien persists on the property. This becomes more problematic for the debtor if the debtor really wants to, maybe there's even equity in the home, and now the debtor really kind of has to satisfy this debt in the long run, because if they want to sell their home, they're going to have to satisfy the lien. Chapter 13 bankruptcy operates a little different. The arrears are, if the debtor wishes to retain the property, the arrears need to be paid at 100%. It's a secure debt arrears, so the debtor would have to pay up those arrears in the case. If the debtor is actually vacating the home and surrendering the home, the arrears would just be lumped into all the other unsecured debt, which depending on the specifics of the debtor's plan, the debtor could be paying anywhere from 0 to 100 cents in the dollar on that. Now, the other scenario is the debtor's Chapter 13 is keeping the home and is current on the HOA dues. In that scenario, the debtor, well, even if the debtor's in arrears or is current, the debtor has to pay the ongoing HOA dues. So, the debtor would ultimately wind up, in a situation where presumably at the end of the Chapter 13, they're current on the dues because they made all the current payments since the case was filed. Additionally, if there were any arrears at the time of filing, those were paid off in the over the course of the plan. So that is homeowners association dues and bankruptcy.